Kati is representative from Hedman Partners, which is a very good partner from Prototron. And just again about the advertisement, that those ones who are lucky ones to win the Prototron, they always with money get the package from the Hedman Partners. To get their shareholders agreement, the essential investors paper or whatever they need to start, they can do it with Hedman. And if I'm not mistaken, then Hedman Partners is one of the leading legal assistants in startup world. So you are really in a good hands when you work with Hedman. So Kati Pino, the Zoom is yours.
Well, thank you. So yeah, and in addition, if somebody has already made it further in their journey, then we recently published a simple convertible loan agreement template, which is available for free as well. I think it was 2 pages, so it's very easy if you're onboarding your first investments. But today, I'll be talking about intellectual property mostly. Because I don't know what you are doing, but I'm guessing that most of you are dealing in software and not in hardware. So, and this is something that I've accustomed to say by now, is that if you're dealing in software, the only thing you have is intellectual property. So it's of utmost importance for startups. But first, some shameless self-promotion. This is some of the clients that we have advised in the past, and some that are currently being advised. So you can see that there are some pretty big names on the Estonian startup scene that we have had the chance to help on their journey. And why this is so important, this is something that you should be aware of, that the Estonian startup scene is very lively and the investments into startups are growing each year. This is the figure from last year, so there is no 2019, but as I remember, it was even higher in 2019 than in 2018. And this is how the investments were distributed among the startups in 2018. As you can see, Taxify attracted the most money, but the others are not too shabby either. And this is why you should think about your intellectual property, because this is one of the first things that the investor looks at while they are deciding on whether to make an investment or not. So what is intellectual property? It's copyrights, trademarks, industrial designs and inventions, which includes patents and utility models, and also trade secrets. All of them are important, but for some business models, some types of intellectual property are more important than the others, but we will look at them, all of them in turn. So copyrights. Copyright is the simplest form of intellectual property, and it's the simplest form of intellectual property protection, because this does not require registration. It's automatic, at least in Europe, and it's granted by law, but it's not public. So people don't know, since it's not registered, other people don't know that something is protected by your copyright, and you are the one who is in charge of enforcing it, and nobody else will do it for you, and you have to monitor it very closely. The upside of copyright is that it's long-term. It's granted for the author's lifetime and 70 years after the author's passing. And the author is the one that calls the shots in case of copyright, how their copyright can be used or cannot be used. And it comes at no cost, because there is no central register, there is no service fees or anything. What is protected by copyright? Software, most importantly to you probably, apps, all kind of software code, source code, object code, all of those, visual designs, and also databases. Databases is a bit different from the general copyright protection, Because for databases, there isn't much intellectual element in it. You just take data and form it into a nice comprehensible database. But it's still protectable because it takes investment. And in case of databases, it's not the author who has the rights, but it's the one who made the investment. So in case of, for example, a firm having a database, then it's the firm who has all the rights to the database and not the persons who actually put data into the database. And the database protection is only granted for 5 years because it's a database. So, but you can elong the database protection when you update the database, but it has to be substantial updating and not just having 2 more lines of data in the database. But for example, if you have 1 more data point, then it is something that's considered substantial, and then you get the protection for 5 years from that point that you included this in the database, even though if the database for like 95% remains the same. This is something that is quite commonly used, the little C in a circle. That does not bear any meaning because copyright is automatic. So you don't need to have it in your designs or have it in your licenses or whatever coding you use. It's used mostly in the US because the US system is a bit different. The copyright protection is automatic. But if you want to enforce your copyrights, then you need to register them in the US. You don't need to do such things in Estonia or in Europe. I have no idea why the US has opted for such a system, but they have. So in US, also the little R in the circle is used, which means like registered. So for them, it might bear some meaning, but generally it doesn't. If you have any questions, then just shoot them. Okay, I'm reading the chat now. Okay, industrial component for electronics. Yes, I will address that as well. So, but I'll get there in turn. So trademarks. Trademarks is something that's important to all of the startups, or just all of legal persons and everybody who wants to provide a service or a product. Trademarks can be very different. They can be words, they can be slogans, logos, symbols. They can also be 3D models, figures and images. And recently also the European Union Intellectual Property Office has allowed for the registration of sounds, with the caveat that you need to represent them. But you can have like a short recording of the sound that you want to have as a trademark. Probably the most known sound trademark is the Nokia tune. For others, I think Nike Just Do It with the little boomerang is a great example of logos and symbols and slogans like all together. Trademarks are registration only. So if you think of a trademark and start using it, then you should also register it. Trademarks are provided for a long-term, they're provided long-term protection. If you register a trademark, then the initial period of protection is 10 years. But at the end of the 10 years, you can prolong the trademark and you can do it indefinitely. So if the trademark is really great, you can, in theory, use it for hundreds of years. Trademark registrations are public. So everybody can check in the trademark registers whether or not such a trademark is registered. And this is something that I also advise you to do, that when you're thinking of coming to the market and thinking of, well, which trademark should we use or like brand name, then have a look at the trademark registers and see that whether somebody has already thought of it or if this is something very unique. Just a hint, somebody has probably thought of it in China and registered it. So it's quite difficult to get a trademark in China. But you should still try if China is one of your markets that you would like to operate in. What's also important is that trademarks are local. So if you register a trademark in Estonia, that doesn't give you the same trademark protection in the US or India or whatever country. However, thanks to the European Union, it's possible to register a EU-wide trademark. And if you are dealing in, I'd say, in more than 3 countries in the EU, it makes sense to register an EU trademark because the costs are not that differentiated. The EU trademark is for one class of goods or services is 850 euros, and the application can be filed online. So you don't need to send any papers anywhere. The Estonian trademark for one class is 145 euros. And this application can also be filed online. When you are registering trademarks or thinking of trademarks, then I recommend using words because the word then gives you the protection to this word. However, if you register a slogan or logo, then this gives you the protection to this particular logo. So if you are rebranding in the future, then you would have to register another trademark with the new logo design. Here I have some examples of trademarks. Some of them have rebranded, as you can see. So this means that they have had to register for a new trademark. So this is why the word trademark is the best. However, in case of word trademarks, it can't be descriptive. So it has to be like out of the box for your goods and services. The most known example is that you can't register Apple for apples, but apples for computers is okay. So this is just something that you should keep in mind. Next up, we have the industrial design, which is something that's way off from the software world. Industrial design protects the product design. So it protects the outward appearance. And it can also be patterns. So if you think of a pattern, how some colors are represented in a pattern, then this can be registered as an industrial design. Industrial designs, just as trademarks, are registration only. So if you don't register it and somebody else does, then somebody else has the registration and you can't use it because they are the registered owner and they can sue you, even if you were the first one to think of it or to just come up with it. That's also true for trademarks. It's the first to file system. So if you think of a trademark and you file for the registration today, but somebody else had applied for the same registration yesterday, then sorry, too little too late on your part, and you have to think of something else. And this is the same for industrial designs. They are short term. Since they protect the outward appearance and trends come and go, then it shouldn't be a monopoly for a long time. So it's for 5 years and it's public. So yet again, if somebody wants to know if this has been registered or which kind of industrial designs your company has registered, they can look it up in the register. And the costs are low, but since the protection is shorter, then that makes sense. The community design registration is for 600 euros. And here are some examples of industrial designs. This is the infamous Crocs shoe and the layout of how the applications are displayed on a device, and some design Christmas tree. And now we come to patents. Patents are the hardest industrial property protection to obtain because they give the monopoly So in case of, for example, trademarks, if you use Apple for computers, then somebody else can use it for heavy machinery, for example. But in case of a patent, you have the monopoly over either the patentable technology. That can be either a device, some kind of a new material, a substance, a method, or a production process. For some things, software has also been able to be patented, but then it's the software process and not the code itself. So it has to be like a method using software, and then it has been patented. Patents are registration only. So yet again, if you don't register it, you don't have it. And for patents, it's very important that you keep everything hush-hush before you file the patent application. Because one thing that that is evaluated upon granting a patent is the innovative step and whether it's previous knowledge or not. And if any part of it has been published before, then the patent authority can say that this is not innovative anymore. This has been published, it's known, and you can't get a patent. So in case you're in doubt that you might have something that's patentable, you need to have strong NDAs and confidentiality agreements in place. Patents are for a relatively short-term protection because of the very high level of protection that they provide. It's 20 years at the maximum, but you need to pay fees for the renewal every year. In case of a trademark, you only pay the fee for once every 10 years. But in case of a patent, you have to pay the fee every year, and the fees are increasing, and the fees are not low. For example, one patent that I had a look at had a renewal fee for the 6th year of 18,000 euros. And the increment is very steep. So this is something to take into account as well. And it's public. So patent registers are also searchable. And it's costly. The PCT fees, they start from 3,000 euros. And patent protection is also country specific. So you need to file for every country separately as well. In Estonia, you can file for a patent by yourself or by using a patent attorney. If you choose to use a patent attorney, then there are patent attorney fees as well. If you apply as an individual, then there are some discounts from the patent fees compared to when you apply as a company. But if the patentable technology is something that the company uses, then usually in case of investments, the investors wish you to transfer the patent to the company, which means then you probably lose the discounts that you have had. Here are some examples of patents, some trolley mechanism, the click and grow, how to grow a herb garden in your kitchen, a chemical compound, and some process for make out what this is. But pretty much this is something that can be patented. And now it's time to talk about trade secrets. Trade secrets is something that pretty much every company has, but they just define it differently. And it's business critical information and know-how. If it can't be protected by other intellectual property forms, then it might be a trade secret. Usually this is the time where I ask what's the most known trade secret in the world. And it's on the next slide, it's the recipe for Coca-Cola. There is no other way to protect it but by a trade secret. But trade secrets, for obvious reasons, are not registered anywhere. They're defined by each company and on a case-by-case basis. And this is only contractual. So if you don't regulate the trade secrets in the contracts, nobody else will do it for you. And if the definition is very vague, then you might have some trouble in enforcing it. And there's no help against third-party invasion. You will have to protect yourself. You will have to know what's your trade secret and how it is defined and what are the contractual penalties for breaching the trade secrets or the confidentiality agreements. On the upside, the protection is very low cost. You just need to work out the definition in your agreements and then see that people adhere to it. And then there's no registration, obviously. As I promised, there's the Coca-Cola picture. So now I'm coming to the conclusions already. So what to keep in mind when you are thinking of IP? You need to keep in mind that the authors own the rights. So when you have some software developers, visual designers, what have you, they own the rights to the IP unless it's contractual and then it's transferred to the company. If you employ people, then according to Estonian law, under the employment contract, the economic rights of IP are transferred to the employer. However, the moral rights are not. This is also very important for software, because for software, the right to make modifications is quite important. And this is a moral right, not an economic right. So you need to think of that. And then sign contracts with all the authors. So because mostly company without an IP is worthless. And you should avoid complex IP ownership. So even if you have separate companies then that are doing the same thing, you should keep IP in one place and not just have it scattered around, because this will make it way easier for the investors to do the due diligence and actually decide to invest in your company. Transfer also the right of registration. So in case of some IP that can be registered, you should also have the right of registration transferred to the company and not keep it with the author. And the first to file is the one who gets the right. So once you have decided that this is the trademark or this is something that's patentable, then you should take necessary steps to register it, or else somebody else will do so, and you snooze, you lose. So suggestions that in case of doing software, the developers or programmers, the best way is to have them as shareholders, because they can be subjected to stricter non-competes. And usually you have a founders agreement or shareholders agreement with which the IP is transferred as well. So this usually creates less problems. Define the trade secrets. You can't say that everything that we do is a trade secret. Otherwise, it won't hold up in court. So just think what's actually a trade secret and what should be protected and what should not. In case of service provision, you should have an IP clause in the service provision agreement, because there is no automatic transfer of IP rights under a service provision agreement. And if you have played yourself into a situation that the IP ownership is complex, then you can use confirmation letters or separate IP transfer agreements to make the IP ownership more transparent and clear. This is it. I'm awaiting your comments and your questions, whichever they might be. These are some additional resources on the Startup Estonia page. You can find all the necessary funding agreements and also investment agreements, which you might need in the future. However, for example, the shareholders agreement is quite complex, so you should keep that in mind and maybe simplify it. Lift.hedman.ee is our page where we also have some resources. And as I said, we recently came out with the simple convertible loan agreement, which is also usable. And Hedman.ie is our homepage where we have blog posts about different relevant topics. So I'm here for you.
So thank you, Kati. We have already some questions, and I will read it for you so you can answer. So yes, this batch is a little bit different, but maybe because we have not top 40, which is also your experience, how you come to talk to us is we have 40 teams. Now we have 58 teams, and they are from Estonia and Latvia. So a little bit much more diverse crowd than it was previously. So we have really very many of different hardware solutions. So I suppose they have got some brief introduction about the IPs from their state. But so let's take the questions. One question is from Olga, is about the company's name. There is another company with the same name in the US. They focus on cyber protection for kids against cyberbullying, abuse, and so on. We are focusing on adult awareness training, social engineering, and GDPR. Can we keep our name to do business in EU, or do we need to change it?
This is a very lawyer answer, but it depends. If the US company does not do any business in the EU, then you shouldn't run into any problems by keeping your name. However, if they are like a bigger corporation and they have some interests in the EU, then they might come after you and sue you for some like because you use the same name. So my suggestion is that it's safer if you change the name, but you can roll the dice and see. Because, for example, I have one example from the legal world. The Estonian law firm that now doesn't exist anymore because they merged with another company, but they used to be called Red Legal. And there was a company in the UK that's also a law firm that was called Reed with two E's. And they sued the Estonian company to change their name. The Estonian company did change the name. They become Primus, and now they have merged with Raidla LX, so they're operating under the name of LX. So it's your decision, but it's safer to change the name if the US service provider is like a well-known. If they have and if they have interest in the EU, I think it's better for you to change the name, especially if you're still in the starting phases of your company. If you have operated under this name for 10 years, then you should take the fight.
Okay, thank you. So I hear the lawyer said you should take the fight. Yeah. So okay. So 2 agreements are required. First, work contract between us and other company, what they will be paying us for. Second, is a mutual collaboration contract which helps to explain who gets to use the results of the research and applications that are developed. Boom, boom, boom. And the question is, how do we figure these things out and develop these kinds of contracts? Maybe you can, like, if you got it, the question?
Yeah, I mean, the second agreement pretty much seems to be like a joint venture agreement or a cooperation agreement. So for such an agreement, you need to really think about who does what and who gets what out of it, if I'm understanding this correctly. So, for example, one party puts in the resources and the other just money, and then they both use the data or the analysis results. So you just need to really think about who puts in what and who gets what out of it, and keeps the right to the actual outcome. For the first agreement, I think this is like a classic, like a service provision agreement. So in that case, you just need to think about what do you do, how much do you want to get paid, and how do you deliver the outcomes. So.
And Nicholas is continues that yes, this is what he wanted to ask, but do you have or can suggest some place to take the specific drafts for this kind of contracts?
Joint venture and cooperation agreements are very case by case, so I can't really recommend any resource. You can find different templates online, but I can't really vouch for the quality of them. And this is not something that Startup Estonia provides, as far as I'm aware. Provision agreements, I think there are some provided by, I think either EAS, I think has some templates on their webpage, but I think they're in Estonian mostly. But you can check it. Like Enterprise Estonia, I think, is the English name.
I will check immediately, and then I will put it in our Slack. Look. So how much does your information, Katya, your information overlap with the US system? What would be good resources for protecting products made for US market?
Mostly the information is overlapping, but the actual nitty-gritty of the registration is a bit different. For example, the US trademark system, they use a different classification system than I think most of the rest of the world. Their registration system is also online, but if you're a foreign applicant, you can't represent yourself. You need to get a US attorney to represent yourself. So there are some peculiarities, but the substance and the core of the information is the same. The good resources, well, if you're thinking about trademark registrations or patent registration, then US Patent Office, I think it's USPTO. They have their own webpage, and they have pretty good like search engines. And for trademarks, I can also recommend you TMView, which collects all the world databases of trademarks. So you can see whether there is a trademark registered in India or Australia. So you can check that as well.
Thank you, Katya. I just try to to understand. There is I suppose Olga is trying still to understand, like, about this first question about the name of the company, that there is this US company also available with the same name. And is there any kind of option, or is it good option to ask from the US company about the name, if I understand correctly? Olga, is it what you meant?
I think that if you ask them, they're gonna say no. I think that this is more likely than, if you go and politely ask them. I think they're going to say no rather than yes. Okay. There is a question.
Yes, again question. The question about the privacy. Our idea is to collect parking information from cameras installed in the public places, more specifically electric poles. As far as I know, we just need to warn the public about the cameras. is there something else, in your opinion, that needs to be done?
Well, this depends on what kind of data you get from the cameras. If the faces of people are recognizable, then you need like more data protection things to think about than just notify people. You also need to have they said just the parking information. What do you mean by parking information? How long I parked there, or what's the number of the car, or
no, just parking. So they want to get the information, is a slot or the place for parking is busy or empty?
If it's vacant or not.
Yep.
Well, then, yet again, it also depends what you have on the cameras, like what the cameras can capture. So if the cameras, like you say that, okay, we only use this to say whether the parking spots are vacant or not, but you have to say it somewhere. So if you say that there are cameras, and if you want to know what data we collect and how we store it, please see our webpage. And then on the webpage, you need to have the instructions, like what we collect and what we do and such things. So you need to say that there are cameras and this is what we collect and this is what we do with it. And people can request their data to be erased under the GDPR. So okay,
so there's a question. Next question is, our website is in 3 languages, but privacy policy only in English. Do we have to translate it to all languages? And the company is in Estonia.
I think it also depends on what kind of service are you providing. Because for some services, it's required that all the information is provided in Estonian, for example, in Estonia, like healthcare or something like that, then you need to have Estonian information. But collecting personal info to sign people up for educational courses, I don't think you necessarily need the privacy policy to actually be in all languages.
Thank you. So because they collect the personal info to sign people up for educational courses, Vlad, sorry for interrupting, but I suppose you should translate it because your main customers are like speaking in other languages besides English, and it's really will be nice if you have this information for them also, because then you should
be understandable for your audience. So if, for example, you're only marketing to Moldova and have the privacy policy in Spanish, then you might run into trouble with the local data protection office.
So please do not go to provide your services only to Moldova. Next one is how to know if a design is patentable. Can I suppose, advertise, for example, on a crowdfunding campaign that the device we are trying to build has potential for patents, but we cannot know until we have money to go through the patent process?
The patent attorneys also provide a service that's called the availability analysis and the patentability analysis. So and that is not super costly. I think it's around 3,000 or 4,000, and at least in Estonia, the Enterprise Estonia or EAS, they also provide some measures for it. So you can apply basically for a grant that helps you to conduct this analysis. So yes, you can say that it has potential for a patent and we will explore it, and this is why we need the investment from you. But for Estonian companies, I encourage you to use the grants that are available as well, because the grants have one of them has 20% own financing requirement and the other has 30%, so it's not that much.
I really suggest you can really to talk with somebody, because if you will talk too much during your campaign, crowdfunding campaign, then you will be in trouble about the patent if there will be somebody will come out that they have been seen already or know something about your idea. So it's really much better to be on the safe side.
Yeah, it's better to keep your cards close to your chest.
Yes, if you're planning to go to patent.
Yeah.
Okay. So the next one is Pauline is asking, what are the privacy policies if children appear in videos we would like to make or use? Do we need written consents, and what would need to be in there?
Well, this depends how you're going to get or make these videos. If these are like produced videos, and then you just make contracts for people to come and star in your videos, then you usually have a written contract. And in case of children, you need the acceptance from their parents. So I suggest written contracts in this case, definitely.
I can also, I'm really sorry, I don't know a lot of like how in Estonia is like what all the restrictions, but for example, I have been worked with UK, and they have a lot like very, very strict and not even strict, but very standardized the process about how to work with children, how to ask all the permissions, and everything should be done in written form, and all the permissions for the pictures, for the permission to take the picture of the child, permission to use these pictures or videos, and like everything should be done, and everything should be in written form, because child doesn't have any kind of chance to be against of it. So really be careful. And if you are really interested, then I can find the templates what I'm using, and they are made for like by a really like advanced policy of UK. So guys, do we have more questions? Okay, Pauline, just ping me later. Nicholas, I'm sorry, where is your second one? Nicholas, please send me your second question, like not in the everyone, but to privately, then it will be much more easier for me to see it.
I think I found it, that they will be patenting a material. Does it make sense to patent the process as well, or should the process be a trade secret instead? Well, yet again, this lawyer answer that it depends. If the process is something that's very innovative, then I think you should patent this. But you should also keep in mind the costs that come along with it. So if you can shoulder the costs and the process is innovative, then you should patent it. But if the process is just incrementally bettering the process that we currently have for such material production or materials like this material that you're producing, then you should just keep it as a trade secret. So, and yet again, this is something that a patent attorney can give you a more definitive answer on. Once they conduct the availability and patentability analysis, they can tell you whether or not it's actually patentable, or maybe it lacks in the innovative step or something like that. So then you can't protect it under a patent, but you can still have it as a trade secret, because it might be innovative enough so that it's not obvious to everybody, but it might not be innovative enough to be granted patent protection.
And just if to say about the experience from Prototron side, all the teams who has had any kind of new material, every one of them have been patent material itself, like some composition and also the process. And some of the materials I know that the main patent is for process. So, but we have had some complicated chemical and biological complexes, so they were patented as a material components.
It also depends what's your business model. If you're going to product, or maybe you're going to license the process. So that's something to take into account.
Yes. So patent will be, but from my side, I really insist that you like put into your mind that patent or if you get the patent, it doesn't mean that you like, so the patent is not equal for business idea or business, like, because I know it's not about you, but really I have a lot of applications that, oh, I have a patent, so now I will become a businessman. And like patent is just about your processes, about your materials, about how you protect your intellectual property. And of course, think also about the contracts which are you making with your developers, with your, I don't know, IT guys, tech guys, because they're also, it means that some IP can go like to the company or it goes to the person. So for startup is much more better. I mean, it's like the perfect when all the IP belongs to the company. It means that you become immediately much more attractive for the investor, because he understands that if he wants to buy company, he gets everything. So he doesn't need to deal later with some persons, with some conflicts and so on. So just think about it that your brain is your main treasure, and treat it well, and treat your company and startup also smartly. Yes, because
definitely. I mean, especially in this circumstances, even if you are doing the startup with your best friend, then you should, trust but control it, or like trust but verify. So just have some trust in your people, but not too much.
It's maybe not even like into people, but life is changed very quickly. We didn't know what is to be in lockdown. Now we know it. So like, never ever could imagine that I will live in this time. And just for those who are running the business in Estonia, it's very easy to make distinguish for the tööleping, the normal contract, working contract. It means by default that authority rights, how you call it in
economic rights to intellectual property are transferred to the employer, but the moral rights are not. In case of service provision agreements or any other type of agreement, there is no automatic IP transfer whatsoever. So for those, you really need to have some IP clauses in them. It helps to have the IP clause in the employment agreement as well, especially if you're dealing with some design or software coding. So
yes, and especially if you use freelancers, then again, this is this option that it's a service, and it means that automatically nothing goes to you. So it should be really written out that everything belongs to you. Otherwise, unfortunately, we have this kind of conflicts among our applicants, that one guy decided to go away and just take everything. So because there were no any kind of paper between them. So I hope that everyone is already writing down all the papers and checking where the IP goes and how to deal with it. So thank you very much, Kati. Hedman Partners also provides the mentors for the next sessions. So if you have really very specific questions and all this kind of like how your business model, like what kind of legal issues should suit your business model or your cooperation or negotiations with investor, then it's always very nice to get to the next step in Prototron and to talk with our mentors from Hedman Partners in private discussion. So thank you very much. For you guys, for Kati, for Yanis, we can close the Facebook streaming and go continue work. And guys, see you on Wednesday. And those who are in Calendly, then according to the calendar. And I'm waiting for landing pages today, midnight. Thank you. Have a nice evening.
You too. Bye-bye.